members, council.
Yeah, I have a brother. I finished.
Oh, you have? Okay. I want to bring to your attention this today is the last day of the second week this jury has been here trying this case. It's obvious, quite obvious to me, this case is going to go into next week. I've inquired of the jury for their desire to work Monday on a statutory holiday. The majority would prefer not to. At the end of the day today, therefore, I presume we'll reconvene Tuesday. One juror has a child scheduled for surgery Wednesday. I don't want to conclude either side from offering relevant, competent evidence, but I beg you, gentlemen, let's try to move this along as expeditiously as possible, but also as fairly as possible. This jury is going to be at least 3 weeks into this trial. So I want to move along. All right, bring the jury in, let's proceed. Cross-examination statement.
Just a couple things I want to follow up with that you talked to Mr. Weill about. You indicated that you made a report to the Attorney General's office of what you believe to be clear violations of criminal law by Robert Smith, the district attorney. Is that correct, sir?
That's correct.
And that had to do with his providing assistance or advice to a criminal defendant.
That's correct. That's true.
You understand that's one of the charges in this very case, sir?
I believe that's the case, yes.
You said also that, Will, that Mr. Smith, in the time that you've been on the bench, has never tried a case before.
He's never not only tried a case, I don't believe he's questioned the witness in the 6 years that I've had on the bench in my courtroom in the jury trial.
And in the 6 years that you've been a circuit judge, can you estimate how many trials you've had in the courtroom, sir?
Well over 100.
And the district attorney has not appeared and tried a single one of them.
Not one of those cases. His assistants have, and the AG's office is trying to great number also.
Mr. Wade asked you some questions about the Attorney General's office representing you in regard to the two grand jury subpoenas you mentioned.
Remember that question, yes?
Is it your understanding, isn't it your understanding, sir, that the Attorney General's office represents you and all other judicial officers in their official capacity?
That's right. Whenever someone, a judge, is sued or served with a subpoena, it happens from time to time, the Attorney General, pretty much by default, defends whatever action is brought.
And you mentioned that your recollection of your understanding that the state's even representing, the state Attorney General's office is even representing Robert Smith.
That's correct. From time to time, people, sometimes inmates, sometimes other folks serve and sue the district attorney himself, and the Attorney General is required to represent the district attorney himself also.
So that's just something that happens in the normal course of events. Is that your understanding?
Yeah, pretty much, yeah.
And the Attorney General's office, in effect, is the lawyer for state officers, public officials like yourself. Isn't that true?
Yes, sir.
Well, I don't know what all this is going, but it seems to me it's outside the scope, and I don't know.
Cross-examination, not limited to direct, counsel, not in Mississippi. Objection over.
I will draw that objection.
There's not anything untoward about the Attorney General's office representing you on the grand jury subpoena. Correct?
No, none whatsoever. I'm glad the AG is there.
And in fact, the Attorney General's office is, in effect, the lawyer for all public officials. Isn't that true, sir?
I'm a statewide elected public official. All right.
Statewide. That's
Yeah.
right. There may be something different for municipal and county and so forth.
Sure. But circuit judges, district attorneys, people of that nature, the Attorney General's office routinely represents.
Yes, they do. Quite a bit.
Sir, I want to show you a document that's been admitted in evidence. A state exhibit 55. Just ask you that will recognize what that is.
I do. It's a docket sheet in the case of state of Mississippi versus Christopher Butler.
And the docket sheet, as I understand, is just a record of everything that happens in a case while it's pending before the court.
Well, it's a little more specific than that. It's a record of, I believe, documents that are filed in a pending case.
Okay. And I just want to refer you to two of the entries in this docket sheet for the Christopher Butler case number. I'll put it here on the screen so you can see this is case number 12452. You see that?
I do see what you have on the screen.
And on May 8, 2015, this reflects an order denying the motion for null prosecution.
The document reflects that, but again, this is a pending case on my docket, and beyond identifying what is on the screen, I can't discuss.
I understand that. I'm just asking you, does the date reflect that that order was entered on May 8, 2015?
That's the date that it appears, yes.
Okay. And then further down the page, does the document then reflect that on December 30th, 2015, there was a motion to disqualify the presiding judge?
The document so reflects.
objection is, being received in evidence this letter, June 6, 2013, county, and
Couldn't be in alternate evidence, I don't know.
A little premature, but that's where we had ultimately, yes.
But it's all,
This will be state 92, I believe.
you know, oh,
That was actually been admitted before I showed it to you, but let me show it to you and ask you, sir, if you recognize that letter.
I do recognize that I haven't seen it in a really long time.
Well, I understand, it's a 2013 letter. And just for the benefit of the jury, Your Honor, this is a letter to you, Judge Weill, dated June 6, 2013. Is that correct?
Yes.
And deal mentions a DER, an issue in a case. In the first paragraph there.
All right.
And the only other question I have for you is this letter came from John Dowdy, the chief of the criminal division in the U.S. Attorney's Office. Is that what it reflects?
That's what it reflects, yes.
And copied on that was Mr. Smith, Kevin Rumlett, Faye Peterson, and Felicia Hall.
That's so reflected.
Judge Weill, there's been some text messages in evidence in this case. You may or may not have ever seen it before. But I'm going to place one of these that's admitted as S24 on the screen here. First message, testimony has been these are text messages from Robert Sheila Smith. First message says, I've charged someone, I'm working on this. Judge Weill is obstructing justice. Question, sir, is in relation to any encounter, any interaction you had with Robert Sheila Smith? Did you ever do anything you would characterize as obstructing justice, sir?
Absolutely not. I'm surprised by that.
Then the next text message says, Judge Weill, Sean, and Patrick for obstruction and conspiracy. And he goes on to say, I don't give a damn about there not being charges somewhere. I'll put it together. The testimony has been Sean and Patrick, or Sean Curran and Patrick Beasley. You know those two men
I do know them, I know them well.
as prosecutors who've been in your court from time to time.
That's right.
And did you ever do anything you would characterize as obstruction with Sean Curran or Patrick Beasley?
None whatsoever.
Did you ever conspire with him in any way regarding this?
No, did not.
And if you had known that Robert Smith was planning to indict you, Sean Curran, and Patrick Beasley for charges of that nature, would you have reported that as well to the Attorney General's officer?
It's a hypothetical. I assume I would have done that because it would have been completely and wildly improper. And I believe that would have fit under the requirement that I report wrongdoing. So yes, sir, I'm likely to.
And you testified on direct that some of the things that Mr. Smith had done to intimidate and coerce you included entering restricted areas of your chamber,
That's correct.
And issuing grand jury subpoenas to you,
Yes, many of those.
and would you have found it indicting you for obstruction and conspiracy, intimidating and coercive, sir?
Very much so.
Bear with me just a moment. Judge Will, I know you may or may not recall the specifics of the hearings. There were 2 hearings on the motion to null process for Christopher Butler case. Do you recall that there were 2 separate hearings?
Vaguely, yeah.
Okay. And if Robert Schuler Smith had argued to you in one of those hearings that evidence had been planted, and in fact there was no factual support for that assertion, would that have been misleading? Elizabeth?
Sir, counsel you asked counsel that you had not done anything to obstruct justice, am I correct?
That's correct.
All right. Sir, if you agree or disagree with me that on the day before Robert Smith was to be arrested or ended up being arrested, you had, as we showed the documents here before, you had an attorney Knox who had been subpoenaed to a grand jury, and you entered an order saying, I'm going to hold this in abeyance, having the effect of this would not appear before the grand jury.
Also, prior to the judicial interpretation of all of the duties and county.
You got to sustain.
All right, sir, what you're telling, let me see if I understand where we stand here. You just told the lawyers that you had not done anything to obstruct justice, correct?
That's correct.
But through your counsel, even right now, you're claiming to refusing to answer any questions about what
Your Honor, I don't object to that. That's totally improper and Mr. Wayne knows it.
I do not know what you're under.
Well, I'm instructing you it's improper. Objection sustained. Don't go down that road.
Let me see if I understand, sir. You have a judicial privilege, and you have a judicial privilege to refuse to answer any questions, as I understand it, about any of your thought processes. You have to come and do that, correct?
I have a judicial privilege, and it's just as valid as attorney-client, or spousal, police penalty, or any of the other many privileges. Yes.
Isn't it true, sir, that also can't give you an exact date, either the day before or a few days before Mr. Smith was arrested, you also entered orders that had the effect of keeping Christopher Butler from appearing before the grand jury. Did you do that, sir?
Object, I think, Your Honor, I haven't seen any of that in this guy.
We did.
I think it's outside the scope of cross also.
I sustain. You sustain.
All right. So, sir, in order to know whether or not you did anything to obstruct justice, we have to know about what actions you've taken or what orders you've taken, correct?
I don't understand that question, sir.
Now, regarding,
Your Honor, I want to pose a general objection here. The notion that Mr. Wade is trying to put on Judge Weill is anything that he does. He may disagree with what Judge Weill did. And he has, under the rule of law, he can take an appeal. What we describe the judge taking an action that he believes in good faith is appropriate as obstruction of justice is an improperly phrased question that's outside the scope of the cross, and I object vigorously to any of those kind of characterizations.
Ask you this question, please.
sir, did you, I'm forgetting about anything you did. Counsel also asked you some questions about Sean McCurry and Patrick Beasley, did he not?
I recall questions about that.
And did you answer, I don't want to misquote you, but did you say in effect that you were unaware of anything that they had done that would warrant them being indicted? Did you make a statement about that?
I don't recall making that statement.
Well,
He may have asked the question. I've been out there a long time. I don't remember.
in course of this case, in the course of the Butler case, have you ever seen it alleged that Mr. Buchanan and Mr. Beasley made an offer to a witness that he could get out of jail if he would provide information on Robert Smith? You ever heard that?
No, Jay, that's what brought out.
All right, sustained.
Would it be fair to say, sir, that you do not know whether or not Mr. Beasley and Mr. Buchanan did anything criminal or illegal? You have no knowledge of that one way or the other, do you, sir?
Repeat the question, there's some movement.
You have no knowledge as to whether or not Sean Buchanan and Patrick Beasley did anything illegal. You have no knowledge about that.
I would have no reason to.
Is the answer no, but you have no knowledge about that?
That's correct.
Sir, you say you're under duty to report to the Attorney General of criminal conduct. What if hypothetically, attorneys relay to a criminal defendant that if you will give us information on a particular person,
True or false information, counsel? Add that to your question. True or false information?
I'm sorry. If they, or let me say those things. You ought to, at this time, in all respect, we go.
Well, finish your question. I'm just trying to assist in an appropriate question to the witness. I withdraw that and retract it and apologize to the counsel. But proceed.
Sir, if you receive information, because you don't know whether, you can often receive information, you don't know whether it's true or not, you just hear about things. Let's say that you had just heard that assistant attorney generals had relayed to a criminal defendant, if you will give us information on Robert Smith, when those attorney generals did not know anything Mr. Smith had done wrong. I'll rephrase the question again. If attorney generals relayed to a witness, if you will give us information on Robert Smith, on what you know about Robert Smith, you can get out of jail. But if you do not give us information on Robert Smith, we'll set a bond so excessive that you'll never get out of jail. Would you regard that as possibly being evidence of obstruction of justice?
No, I object, it's outside the scope.
I'm going to sustain the counsel. It has to be a known process and not only being irrelevant, but of sustain.
Sir, if I understand what you're saying, if you learn that the Attorney General was about the district attorney, and I believe you said you didn't know at the time, looking at that text message that shows you know now, that the district attorney was about to at least present a case against you to the grand jury or indict you, and it was for something that you had not done anything wrong, you would then go and report that to the Attorney General, am I correct?
No, I object to speculation and
I'm going to let him answer the question over with.
That would be the type of information that would likely make the report wrongdoing. But if we're in a hypothetical world, and I wasn't aware of it at the time.
Would you expect if you reported to the attorney, if you reported that to the Attorney General, then the Attorney General might take some action to keep you from being indicted? Would you agree with that?
Jay, cause speculation what the Attorney General's office might be.
Sustain.
Is taking action to prohibit a person from being indicted, would that constitute hindering prosecution?
I don't see how that doesn't do anything but ask for his mental opinions and conclusions. Sustain.
Do you know whether or not by indicting Robert Smith, the Attorney General's office hindered the prosecution of two assistant attorney generals? You know whether they did that or not?
Sustain.
That's all I have.
All right. You guys will stand down. Thank you, sir. Your time is good. Thank you. I know you would love to. Yes, sir. You know this. next witness for the defense. Say again. Tommy Davis.
Should be right outside the court.
All right.
Witness in the courtroom, Your Honor.